Good afternoon. Good afternoon. We are back unexpectedly today in the Chad Daybell trial with breaking news. So, and I should have known better. It's a court streaming rookie error to leave the court feed before it closes permanently, because especially after the state rests its case, because it is hello liberty, hey truth matters, because it is very common and normal for hello Rachel, for the defense to issue a motion to dismiss after the state rests. And that's very normal. And that is what Pryor did. He raised a motion to dismiss and argued that motion. And apparently the state, hey, Stacy, apparently the state countered and gave good arguments. But then Judge Boyce raised a major issue. And that is that on the indictment, the amended indictment, hello, Grandma Sherry, hello, Jackie. In the amended indictment, which is the indictment that they are using for the murder of JJ Vallow, they listed his death date as September 8th. But they tried his case as his death date of September 23rd. And of course, there is digital evidence showing that he is alive after September 8th. That's a major issue. And the state was apparently stunned by this. So before I keep talking about this, let's watch what happened. And then we're going to watch some of the family and journalist reaction to it, people that were on the scene. And at 2:30 their time, 2:30 their time, court's going to come back with their decision. They are in chambers right now talking about this. Marcia, it's a good question, but I got to tell you, I am absolutely shook by this. I am shook. Now, I got to remind you that do you know why Lori Vallow did not get the death penalty? It was a state error. It was because the state didn't turn over its evidence on time. That's why. Not because she didn't deserve it, not because the state didn't turn. It was an error by the state. Of course, they're not going to be perfect, right? Of course, but critical errors like this in these major cases are infuriating. 5 years, Liberty, 5 years. 5 years. And that amended and then we've got this other case, this major quadruple murder with the Idaho 4. And some of the same prosecutors are on that case. And so I don't accuse them of corruption. I accuse them of, some of them of incompetence. But let's watch this and see what happened. And forgive me if I fast forward through part of it, because some of this is routine and some of it we know happened. But what's most important is when Judge Boyce starts to talk about this date issue.
Defense is requesting to have a motion heard. We do have the defendant here along with defense counsel. The state's also present with the prosecutors. The jury is not present in the courtroom at this time. This motion will be argued outside of the presence of the jurors. Mr. Pryor, if you'd like to make a motion at this time, you may.
And Judge, this is a motion for a directed verdict that is permissible under the criminal rules. I'm going to do this, Judge, in a general sense without getting into specifics, but I'm going to move for a directed verdict on the murder charges. specifically with the Tylee and JJ, there is no indication that Mr. Daybell was present, took an active part in, or facilitated in any way the murder of JJ and Tylee. In regards to the conspiracy charges, there's no indication that there was any act that he took in furtherance. There's reference to significant religious discussions, but that in itself is not an action in furtherance of those charges. Lastly, Judge, in regards to the fraud, the only testimony I recall is that the insurance was upped from $10,000 to $80,000, and that there had already been a longstanding $300,000 policy from 2002. At this point, I don't think the state has met its burden regarding the fraud. And again, I don't think they've met their burden regarding the conspiracy on all of the conspiracy charges. And they have not met their burden in regards to the murder as set forth previously.
All right, thank you for the argument, Mr. Pryor. Who's going to be responding for the state?
That would be me, Your Honor.
All
And I
right,
think,
Ms. Beatty, you can proceed with a response from the state.
thank you, Your Honor. On a motion for directed verdict, Your Honor, the state is entitled to all reasonable inferences that can be drawn from the evidence. And I think the case law is pretty clear.
So long story short, this particular motion is dismissed, but let's fast forward to when Judge Boyce brings up this date issue, okay? Because that's the most important part.
That a view given from that empty theories or special inference that these beliefs that the defendant was espousing, her Ryan, multiple to co-conspirator that listed prior that the defendant was living that the defendant and even consideration religious belief. We've co-conspirator took customers number to used to conspire last seen a lottery, and the jury heard evidence about what Alex was doing when the defense is guilty of the murder of JJ Vallow. As to count 5 of submitted regarding death percentages on July 30th, the jury did hear evidence in this very morning, Your Honor. Overt act along with that number 14th of October. All of the first-degree murder of and trapped he felt, but how freedom was coming. The defendant's mistress, Lori Vallow.
JJ Vallow.
There was a clerical issue. Thank you, Your Honor. As the final two. There was a clerical issue. Thank you, Your Honor. As the final 2 counts of insurance fraud, I won't belabor this since we've already discussed it in the conspiracy portion, but the evidence does show that the defendant and Lori began an affair in 2018. Months later, Lori's killing was Taffy.
Rule 29 of the Idaho criminal rules, and this is a motion for judgment of acquittal, which reads that we're now at the time the prosecution has closed its evidence, and if the court finds, based on the standards cited there by the state, insufficient evidence, the rule reads, must enter a judgment of acquittal of any offense for which the evidence is insufficient to sustain a conviction. I've listened throughout the trial to all of the evidence submitted. There's multiple counts in this amended indictment. As I've gone through those, I'm prepared to make a ruling on nearly all of the motion here, but there is one particular issue that has arisen in the charging document, and I'd like to address that with the state if I could. So in the initial indictment filed in this case on May 25th, 2021, and I'm looking at count 4, which is the charge of first-degree murder involving JJ Vallow. Initially, it was alleged that, quote, on or between the 22nd and 23rd of September 2019 is when the murder was committed. The state amended the indictment on February 20th, 2024, and under the amended indictment, the count 4 now reads as follows.
So whoever amended this indictment a few weeks ago, in February of this year, better be listening.
The defendant, Chad Guy Daybell, and Lori Noreen Vallow, on or between the 8th and 9th day of September 2019 in the county of Madison, state of Idaho, and then goes on to describe the allegations about the murder of JJ Vallow. When I look at the evidence that's been presented here from the state, the evidence not only does not support a finding of the dates between the 8th and 9th of September, but contradicts that in that JJ Vallow was clearly alive after the 9th of September from many witnesses, including testimony today. And so I have some concern that the charging language, which would control in this case in the amended indictment, cites a date.
I'm going to stop it there and get closer up into what the people look like in the courtroom as this is being said. This is the defense table. I'm sorry, the state table. Look at Mr. Wixom here covering his mouth like, holy crap. Holy crap. Is he the one? Is he the one that made this error? Who made this error? Stand up.
Date range that does not comport with the evidence. And I'm concerned about
Look at Lindsay Blake.
instructing jurors with evidence that I believe was never presented here at trial.
Rob is just bowing.
It's an issue identified as we prepared for this hearing today. I understand the state may not have been aware of that. It wasn't argued by the defense, but the court has its own duty to also review the evidence and under 29,
I want to cry.
point out anything that may be considered for a potential judgment of acquittal. And so I don't know if the state is ready or willing to address the issue on the dates contained in count 4 now, or whether the state would like some additional time to look at the issue and perhaps come back a little later this afternoon and present some additional argument or authority. But I have a concern about count 4. The testimony does not comport with that. I'll note one additional point. We have an on or about instruction that's already been given and will be given.
Should Liberty.
In some of the counts in the amended indictment, there are on or about language. There's also others that have on or between language. And in my mind, a plain reading of an on or between still gives a date range, but the range is from one date to another. And I don't know that that's the same as on or about, which allows maybe a further deviance of times listed in the charging information. And again, count 4 reads on or between the 8th and 9th of September. So, Ms. Beatty, do you have any response to the court's concern as it relates to count 4?
And Your Honor, if we could come back and address that perhaps Monday morning, so we have the opportunity to review that prior to the defendant's case. I'm not sure anyone was aware of.
And Judge, I need to respond
They
for the
weren't
record.
aware.
Yes, why don't you, I did say a lot there, and Mr. Pryor offered the state a chance to respond. Any response from the defense, Mr. Pryor?
Judge, state has had an opportunity and an ample opportunity to review their pleadings. They've made amendments of those pleadings once, and we had a hearing on those amendments in which I agreed they could make whatever amendments they wanted. And now we sit on the eve of the defense starting their cause. The state has rested.
I hope he's right, Crystal.
The defense has made a motion under Rule 29 for a directed verdict. I don't think this gives the state the ability to make any modifications or amendments after they've rested their case, and at which time I've made a motion for a directed verdict. That motion for the directed verdict, Judge, tolls the state from making any further adjustments to the accusations they're making against Mr. Daybell, and I'm suggesting I'd ask the court to make its ruling on my directed verdict.
All right, I'd note there's actually a rule that governs this directly. Idaho Criminal Rule 7E. The court may permit amendment of an indictment, quote, at any time before the prosecution rests. So I do agree with the defense there that amendment of the indictment's not permitted at this stage in the trial. In terms of the timing and the request by the state, the issue with waiting until Monday is if the defense is going to be prepared to start with its case in chief, the defense is entitled to know what it's defending against and if potentially one of these counts.
Actually, Liberty, it was the judge who found it himself. He said it. He said, the defense did not bring this to my attention. I noticed it myself. So the defense didn't even argue it. And there actually isn't a defense team. The defense team is John Pryor. So yeah.
House is dismissed on a judgment of acquittal under Rule 29, that would affect potentially, in fairness, preparation for the defense. So in my mind, it's a fairly narrow issue where we have a filed amended indictment. We've got Criminal Rule 7E, we've got Criminal Rule 29. We've got our jury instruction number 4, which might be relevant on the honor about or honor between language. And I think with the prosecution team all here, I'd like to get this done and determined this afternoon. So it might feel like quick timing, but I'll give the state 2 additional hours to prepare for any further argument or authority. And we'll come back on the record at 2:30 for further argument and
Yes, Harlot, that was the judge speaking. Just then, that was the judge speaking. So what he was doing was basically saying, sorry, state, you can't have till Monday to prepare an argument about this. You have 2 hours, which was about an hour and a half ago or so. So in about 25 minutes, they are due to come back to get this. I'm not sure if they're going to be actually arguing when they come back, or if judge is just going to be giving his decision, but we're going to be hearing more about this when they come back.
potentially ruling on this, including all the remaining counts as well. So we'll be in recess until 2:30 and we'll come back then.
All rise.
Let's get a closer look at everybody as look at them. And then they shut it off. All right. So what we're going to do now is look at the reactions of the family and reporters outside after all of this happened. I have to tell you, when I saw this, I literally, I was in absolute, complete shock. Speechless shock. Remembering that the reason that the death penalty couldn't be delivered on Lori Vallow was because of a state mistake. And that's what happens with these big cases. There's so much to juggle. And then they make big clerical errors like this. Yeah, disorder in the court is all one word. Maybe that's maybe an issue of me needing to change the way my name is. But thank you for saying that, Crystal. All right, let's watch this. This is the reaction from Lauren at Hidden True Crime. Yes, they are, Harlot. This is death penalty. All right, I will break down what just happened. Okay, I'll break it down again. So the state rested their case. They ended their case against Chad Daybell. Okay, it's very normal for after the state has rested their case for the defense to issue a motion to dismiss the case against, it's a very normal part of the process. So Pryor submitted a motion, he argued a motion to dismiss, and then the prosecution argued against the motion to dismiss, but then the judge started to talk about his decision, which is again a normal part of the process. After hearing the arguments on either side, he said, okay, I've heard both of your arguments, hey Teacup, but I have my own issue to raise, which is I've noticed that in the amended indictment for the murder of JJ Vallow, this amended indictment that was amended on February 24th, it states that he was murdered on or about September 8th. But the initial indictment stated that he was murdered on or about September 23rd. He can't have died on or about September 8th because there is evidence of him living, even what was presented today. So basically, the bottom line is there was a major clerical error that could cause the indictment for the murder of JJ Vallow to be thrown out, because the law may prevent it from being kept in because the state has already presented its entire case. Because at one point they were talking about, well, we can still, we can issue a new amended indictment. And the judge basically said, well, but you have now rested your case. And based on, law, blah, 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 our state law says that once you have rested your case, there is no, there's no going back. So what you'll hear now is what I'm going to now. So hopefully that breaks it down to you. Let me know if you have any questions. I will answer them if I can. If I can, I'll answer them. But in about 20 minutes, they're supposed to come back and we're supposed to get the decision about this. And hopefully it won't result. It is tragic. Hopefully it won't result in JJ's indictment being thrown out. So, of course, all the family members and, the people in the gallery and the journalists went out and started, doing reactions. And what you're seeing here is Lauren showing Larry Woodcock being interviewed by some reporters, and you can't hear him very well. So I'm going to fast forward to the part. We're going to fast forward to the part where you can actually hear Larry and Lauren talking to each other, because at this point you can't really hear it. Opinionated is asking, why did the judge wait until they rested? I can guess on that answer, and I think it is because that's when the question was on the table. And it may be just when he noticed it, right? But I don't know for sure. I don't think the judge can weigh in on things until they are on the table in front of him. So, and maybe that'll be addressed, in the, when they come back. But he may not have noticed it until he was considering the motion to dismiss. I'm sorry. I'm sorry. I totally, literally just ended a recap and I don't want to recap again. I need to move forward. So you can turn back maybe about 2 minutes and you'll hear that recap. So let's continue to watch this.
Oh yeah, would you mind holding it, Trista? Okay, I'm gonna have some. It does have to be kind of close because actually, you know what? I'll just do it so you can kind of see. Okay, thank you. But, yeah, thank you.
As you can see, Lauren is wiping tears from her eyes.
That was a bombshell. So, and just for everyone joining here, I just started my.
Also, for anyone who is looking for a recap, you're going to get a bit of a recap here as well. Lauren's going to give a recap as well here.
Lunch live just as fast as I could. There was a bombshell just dropped after the prosecution rested. And the concern is, and I'll share this, Larry, really quickly, and then we'll talk. The concern is after the prosecution rested, they argued, there was a motion presented that Chad Daybell, wanted to be acquitted, and Ingrid laid out all the evidence they have. Like, it was solid. It was solid. And then Judge Boyce brought something up where he said that he has concerns with the language, and that for the count of JJ Vallow, Larry's grandson here, that they amended the indictment on in February, and when they amended that indictment, they switched JJ's death date to being September 8th, 8th and 9th, which is actually the Tylee's death date, and switched it from September 22nd and 23rd to the 8th and 9th. And you could hear a pin drop in the courtroom, and it seemed like the state was pretty shocked too. Like, they had no idea. I was watching you, Larry, actually, with your head hung kind of like it is now. And there was this, so then they asked if they could argue this and change this. They were kind of scattered. You know, they didn't realize it after on Monday before defense. And the judge said, well, the rule, the precedent that's been set is that once the prosecution rests, kind of like that's it. But we're going to meet in 2 hours back in the courtroom. He said, we need to take care of the situation now. Pryor would kind of look smug and then was smiling. And I don't know. I'm not an attorney, but we walked out and gasped. And I didn't come down here right away, Larry, because we were just up there trying to process everything. And there's a group around us right now too, just so you know, like, we're trying to process this. But do you know anything? Have you talked to anyone? Have you heard anything?
No, I haven't, Lauren. I was shocked, and honestly, I wish I had an attorney available to explain this. I wish somebody could explain it in the technical terms and what are the options. In my mind, it was just like, okay, JJ's irrelevant, and that just hurt. That hurt. It just hurt.
This is absolutely devastating. Devastating. These people, especially this man, has been sitting in that courtroom every single day. And I'm telling you, he doesn't look well, you know. It looks like it's taking a toll. And good question, Stacy. I mean, somebody needs to be helping these people make sense of this.
You've been here every day of the trial. Larry has been here every day of this trial for justice for your grandson. And to think that this count, I don't know what it means either. I don't want to jump to it either. I wish I had an attorney here too. But to hear that this count, thank you, Laura, this count of first-degree murder for JJ Vallow. Have you heard anything? Not yet.
I'll let you know as soon
We
as I
have attorneys on speed dial right now, guys. We're reaching out. And there's a crowd around here, just so you guys know, like, everyone very concerned right now. I had a full lunch life plan, guys, and I was going to talk about the powerful last witness, Agent Hart, and the damning texts and the powerful evidence that was shown, and it was indeed powerful. And this motion, that's for later. Right now, this motion, we're all kind of shocked right now. Like I said, there's a group of us. We're all hanging out. We're trying to figure out what's going on. We don't know. Have you heard anything, Nate? Nate Eaton's here too? No? I mean, it's yeah, we're all waiting. We have some attorneys on speed dial. I don't know if you've reached out to anyone, making some calls. So yeah, we're trying to know what this means. There's going to be a 2-hour break. So it's 12:45 here in
2:30.
2:30. Yeah, a 2-hour break, 2:30. So it's 12:45 here in Boise, and in at 2:30 we're going to go back to learn more. And I want you guys to see too. I'm just going to show you guys. This is kind of what's going on. Sorry, I'll just go fast. But we're all around here. These are all the people in court. It's like kind of like a community right now, and we're heavy. And this is going on. So if everybody could send your vibes and energy and prayers right now.
Amen. Send those good vibes to the people in Idaho right now in front of that court who are devastated, let down by this. So I'm praying that there's some crack lawyer who's watching this from Idaho who knows the precedent, knows the case, can pull it up right now. Pull it up right now and say, look, this is easy. It's an easy fix. It's an easy fix. Come on, people. Come on. Rally. Let's rally. This cannot happen.
So what's going on? Let me remind people just getting here. It was an amazing day. It was an amazing day. We've been taking notes. Hidden Gems have been helping to transcribe texts. I was going to read them all to you. It was powerful. There were so many mic drop moments, so much evidence to show that Chad Daybell is responsible for the deaths of JJ Vallow, 7-year-old JJ Vallow, 16-year-old Tylee Ryan, and 49-year-old Tammy Daybell. And then after the prosecution rested, and it was so great. And Larry Woodcock has been here every day since April 1st for a month and a half. And it was this moment, and then emotion. And then we came back, we had a recess. And John Pryor was arguing an acquittal of the charges. And Ingrid laid it all out, like boom, all the evidence we've shown. She was a rock star, it was awesome. And then Judge Boyce said, but what you argued for is JJ Vallow, evidence that JJ Vallow was killed on September 8th or 9th. And he wasn't. He was alive. Evidence doesn't show that he was killed that day. You guys amended this indictment of these charges, and this first-degree murder charge of JJ Vallow is actually the date is wrong. That we know that JJ lost his life on September 22nd, 23rd. John Pryor was smug. He was smiling like he had known something. Judge Boyce looked concerned, but he can't change the law. And then they said something. The most frightening thing was that he said, look, this is supposed to have happened and be changed before the prosecution rests. So we're coming back in 2 hours.
Oh my God. This is just.
Larry, is there anything else?
Crazy
I'll turn this off here. But is there anything else? Are you okay?
I'm okay.
Okay.
I just,
Hey, Music City Mom.
I think Judge Boyce did it right, because I'd rather address this right now than to address it or let the.
You see, listen to that. That's class. Can you imagine how devastated he is? How angry he must feel. But he's saying, hey, look, I'd rather deal with this now than deal with it later. And he doesn't know what the outcome. He doesn't know what the outcome is going to be. It could end up not being in his favor. Right? But he's still giving the judge his props and saying, hey, look, I'd rather know now. I'd rather figure this out now than find out later after a guilty verdict.
Superior Court address it and get a mistrial.
Right.
So I think it's on Judge Boyce's part. I think he made the right decision. I think I really wish there was some there was an attorney that would explain this.
Right.
And what if and what can. And, uh, you know, look, we've been steadfast for 5 years. We are not going to back off of this now. This is, it's a simple of this now.
Look at him look up at the camera and stare straight at it and say, look, we're not backing down. We're not backing down. And I'm sure that even if the decision doesn't go their way, that'll still be their energy and their focus.
This is, it's a simple case. 2 children's murdered. 2 children were murdered. 3 people were responsible. There was a gang around them that I feel has always been responsible for part of this. And if the prosecution made an error, and that error excludes JJ, do I accept it? No. Do I want it? No. But will I accept it rather than a mistrial? Absolutely.
Right.
But I don't know. I don't know the definitions. I like details. Give me details.
Yeah.
And I think everybody here is waiting for details. And it's
I'm not sure.
it's hard. I am
Wait.
so hurt.
Getting the Poodler.
Not for me, but for JJ.
It's just too much to take, man.
We'll
Too
be
much
okay.
to take.
We'll be okay.
We'll be okay.
It will be okay. I think that too. I think it's going to be okay. But I just want you guys to know the lunch live I was ready for. I had pages. I was going to read a bunch of texts. We're going to wait until.
So they should be coming back. Hopefully, if they're on time, they're going to come back in a few minutes. But I'm also going to show you what Nate has to say here.
Happened just moments ago. Big news here at the courthouse. I'm going to go over here to get out of the traffic. The prosecution rested this morning, and then
Liberty, I'm not sure if it would be a directed verdict for JJ. I don't know. I'm not sure. That's kind of a legal. Hey, Great Dane Mom. It's kind of a legal conclusion I would have to make, but I guess that's a possibility.
the defense argued kind of a procedural type of motion that the state didn't prove their case, and that that Chad Daybell should be acquitted. This is a standard type of thing that that happens in most cases. Judge Boyce noted that on the indictment on count 4, on the murder of JJ, the state has on the amended indictment that JJ died between September 8th and 9th. He didn't. He died between September 22nd and 23rd. And so the state has rested. And if you look at the indictment, the state did not prove that JJ died between the 8th and 9th. The state says they proved that he died between September 22nd and 23rd. Nobody caught it. Nobody caught it until today. And so the state asked if they could come back Monday morning and address the issue. John Pryor said, no, the defense is starting Monday morning. I should have a right to know what I'm arguing. Am I arguing that charge or not? Judge Boyce has given the state 2 hours to come up with a response on how they can possibly amend the indictment if they can. Remember, this was an indictment that was already filed and amended. So many of you.
I wish I was kidding, Melissa. I wish I was kidding. This is absolutely devastating. Now, we don't know the answer yet. We don't know what's going to happen. That was an unfortunate pause on Nate's face. Sorry, Nate.
Are confused. Let me just give you the brief rundown about what happened. The state rested today. After the state rested, John Pryor argued a relatively routine motion saying that the state didn't prove their case and the charges should be dropped. Judge Boyce said, I'm ready to rule, but I have one issue. On count 4, the murder of JJ Vallow. It says on the indictment that he died, that he was killed between September 8th and 9th of 2019. The state did not prove that.
Recess after the court heard argument on the defense motion for judgment of acquittal under Criminal Rule 29. I indicated an
Okay,
issue
here we
with
go.
count 4 and permitted additional
go.
time for the state. Before going into more argument on count 4, I have taken the time to prepare a ruling on the other counts on the motion. And I think for efficiency purposes would go through the ruling I've got as it relates to the other counts in the case, and then reserve some additional time to further discuss where things will stand with the count 4 of the amended indictment. So proceeding in that manner, the court would first note that the motion under Rule 29 for a judgment of acquittal, as I mentioned before, is for the court to consider whether there's evidence insufficient to sustain a conviction. There's some case law that goes further into the standard of review on that, or the burden of proof the court looks at in determining this motion. Some of it cited appropriately by the state. I'll note from a case, State versus Taylor, 157, Idaho, 186, talks about, says under ICR 29, the district court may set aside a jury verdict or enter a judgment of acquittal if the evidence is insufficient to sustain a conviction. The 14th Amendment of the United States Constitution guarantees the right to due process, and the U.S. Supreme Court has held that as part of that due process, quote, no person shall be made to suffer the onus of a criminal conviction except upon sufficient proof defined as evidence necessary to convince a trier of fact beyond a reasonable doubt of the existence of every element of the offense. And there's some internal cites there. Going on, the case states the relevant inquiry is not whether this court would find the defendant to be guilty beyond a reasonable doubt, but whether, quote, after viewing the evidence in the light most favorable to the prosecution, any rational trier of fact could have found the essential elements of the crime beyond a reasonable doubt. And that cites a case, State versus Adamanchik, 152 Idaho 460. And then finally, thus, the only inquiry for this court is whether there is substantial evidence upon which a reasonable jury could have found that the state met its burden of proving the essential elements of the crimes charged beyond a reasonable doubt. Substantial evidence is more than a scintilla of proof, but less than a preponderance. In short, it is relevant evidence which a reasonable mind might accept to support a conclusion. So finally, the court is required to consider the evidence in the light most favorable to the state, but will not substitute its judgment for that of the jury on witness credibility, weight of the evidence, or reasonable inferences to be drawn from the evidence. So that's the standard of review the court considers in ruling on a motion under Criminal Rule 29, starting then with the counts that I am prepared to rule on count 1, having considered the arguments of the defense and the state, the court does find that the state has presented sufficient evidence that would permit a reasonable trier of fact to find the essential elements of the crime beyond a reasonable doubt. And that's on the conspiracy to commit first-degree murder and grand theft by deception involving victim Tylee Ryan. The court notes that on identification of the defendant, which is one of the elements, he was identified by several witnesses, including Detective Ray Hermosillo, Ron Arnold, Detective Kaya Kamanu, that in terms of the dates listed in count one, surveillance from Officer Joe Powell helped establish those in the testimony of the other witnesses I mentioned, that this occurred in the county of Madison, state of Idaho. There were locations testified to by Officers Joe Powell, Colin Nesbitt, that the victim, Tylee Ryan, was identified in that count by, among others, Colby Ryan. Looking at the overt acts that the state went through and alleged 1 through 7, the overt acts, evidence of those came in sufficient to withstand a Rule 29 acquittal from Detective Nathan Duncan and Zulema Pastenis testified to some of this. Also on the second overt act, Michael Douglas, Mark Sari, Chuck Consitis. Also Chuck Consitis on the third overt act. Detective Nathan Duncan testified on issues related in the fourth overt act. On the fifth overt act, Nicholas Balance and Nicole Heidemann testified about that. On the sixth overt act, Mark Sari, Chuck Consitis testified regarding that, and Mark Sari also on the seventh element. The court then, in considering that standard on a Rule 29, finds there's sufficient evidence, and so the motion's denied and the jury will be allowed to consider count one. Count two is the first-degree murder charge of Tylee Ryan, and evidence was provided identifying the defendant by witness Ron Arnold. There was date indications of when this occurred established by Rick Wright, among other witnesses. And the plan that is referenced in there was also testified to by Rick Wright and Nick Edwards. There was also information about identifying Tylee Ryan, identifying her as a person by Colby Ryan, Tara Martinez, Dr. Garth Warren. And looking overall at the evidence submitted, the court does find the state's met its burden to withstand a Rule 29 motion, and count two, the judgment of acquittal motion, is denied. Moving next to count three, conspiracy to commit first-degree murder of JJ Vallow. The court notes there was sufficient testimony and evidence presented to also deny the motion for judgment of acquittal on this count three. The identification of the victim established by witnesses including Kay Woodcock and Brandon Boudreau, that the overt acts again were testified to by witnesses including Zulema Pastenis, David Gibb, Ashlyn Rand, David Warwick, Melanie Gibb, Colby Ryan, Ray Woodcock, Mark Sari, all testified among those actually six overt acts that are alleged there. The court does find sufficient evidence in testimony and admitted exhibits to allow the state to move forward and seek jury deliberation on that count. I'll skip over count four, as I mentioned. On count five, this is the conspiracy to commit first-degree murder of Tammy Daybell. Also, the court denies the motion for judgment of acquittal under Rule 29. In that particular count, the identification of the victim was established by Samantha Gwilliam and others. The defendant was identified relating to that count by testimony from Craig Huff, Zulema Pastenis, Colby Ryan. Looking at the overt acts established, there were 12 in that count, and the court notes that there was, again, identification of the victim, Tammy Daybell, by Samantha Gwilliam. On count one, some evidence came in through testimony of Jason Gwilliam, Ian Pulowski. Count two, Ashlyn Rand and Chuck Consitis testified about the overt act there. Count three, Nick Edwards. Count four, Nicole Heidemann. Count five, Nick Balance. Count six, Zulema and Nick Edwards established some testimony to allow those overt acts to be considered. Count 7 had some testimony from Angela Yancey. Count 8, Coulter Cannon. Count 9, Nick Edwards. Count 10, Rick Wright. Rick Wright also on count 11 and 12. And also Nick Balance testified about overt acts in 11 and 12 also. And considering the standard I announced at the beginning of the ruling, court does find that there's sufficient evidence the state's presented to deny the motion on that count 6. Count 7 is the insurance fraud count. The defendant was identified as to that particular count, among other witnesses, by Craig Huff, and Angela Yancey established the date range that's in the count. Also Taylor Ballard, and the state did provide sufficient evidence regarding the allegations of the insurance fraud count to withstand the Rule 29 judgment of acquittal. Similarly, on count 9 of insurance fraud, again, the defendant was identified by Taylor Ballard. The date range was established by Angela Yancey, who testified also that that occurred in Madison County. Prior count also, the venue of Madison County was established. And then also Angela Yancey established evidence relating to the allegation of a fraudulent claim as set forth in count 9. So upon considering the evidence presented in the state's case in chief on those counts, the court is denying the motion for judgment of acquittal. And at this time, the court is going to permit some additional argument from the state as it relates to count 4, the first degree murder count, as it relates to JJ Vallow and the issue the court brought up. So Ms. Beatty, are you prepared to argue that?
I am, Your Honor. Thank you.
I'll hear
Okay, so they're
additional
gonna
argument on
argue.
count 4 then from the state, and I'll allow additional rebuttal argument as well from the defense.
Oh, God.
Thank you, Your Honor.
Thank you, Marcia.
Your Honor, in looking at the case law and the relevant rules and statutes, the state really has 3 options for the court at this point. The first, and I'll talk about each of them in a little more depth, but the first option would be because count 4 of the amended indictment did not fall within the scope of the court's December 8th, 2023 order to amend, and we'll get to that in a moment, the court can simply correct it under Idaho Criminal Rule 36 so that it conforms with what count 4 should be, which would be count 4 as set forth in the original indictment. And I'll discuss that more in a moment.
Sounds good to me.
Second, the court could accept that we do have a variance here and either instruct the jury on a variance between the jury instructions and evidence that they've heard, or the court under State versus Jones, which we'll also discuss in a moment, the court could address that variance by simply putting in September of 2019 in the count 4 jury instruction, which is very similar to what the court in Jones did, as we'll discuss in a moment. Third and finally, the court would be within its discretion to reopen the case to allow the state to correct the indictment if the court does find that it needs to be formally amended. So as to the first option, the state did not move to, and the court never granted a motion for the state to amend the indictment as to the date or as to count the date within count 4 as to anything about count 4. Under Idaho Code 19-1420, the state can only amend without leave of the court prior to entry of plea. Under Idaho Criminal Rule 7E, the court grants the state leave before amending a charging document. In this case, the state made a motion to amend the indictment on November 23rd, 2023 in 3 very specific ways. The first was to modify the subsection referred to in counts 1 and counts 3 from Idaho Code section 182403 sub 4 sub A to section 182403 sub 2 sub A. The second change requested by the court was to modify the language in counts 2, 3, and 5 from, quote, the defendants, Chad Guy Daybell, Lori Noreen Vallow, and Alex Cox, unquote, to, quote, the defendants, Chad Guy Daybell, Lori Noreen Vallow, and or Alex Cox, unquote. Finally, the state requested that leave to amend the indictment to modify the language in overt act 10 under count 5 from quote month unquote to quote months unquote. Importantly, Your Honor, nowhere in the state's motion did the state ever seek leave to amend any portion of count 4. On December 8th of 2023, the court granted the state's motion. The court's order states, quote, for the reasons stated on the record, the court will grant the state's motion. The amended indictment is ordered to be filed in the case, unquote. Subsequently, of course, the state did file an amended indictment, but in that indictment, it does appear that the date within count 4, the first-degree murder charge of JJ Vallow, was inadvertently changed to the same date as the murder of Tylee Ryan. The state would note that the initial indictment was filed in this case on May 25th of 2021, and in that indictment, JJ Vallow's death dates were properly set forth as the 22nd and 23rd of September of 2019. Just 2 days after that, counsel for the defendant filed his notice of appearance in the case. This matters in the court's analysis because it goes to prejudice and it goes to notice where we had an indictment with the correct dates for 2.5 years, during which in the entirety of that time, counsel and the defendant were aware of that date range. And we'll discuss that in a moment as well. Ultimately, because this is a clerical error that needs correcting and count 4 was never properly, was just simply not amended in any legal sense because the state is not able to do that without leave of the court, and the court did not grant the state leave to do that. The court could utilize Rule 36 to make that amendment. Certainly, this would require a jury instruction of some type, and the state does not have a proposed jury instruction because the jury was read the indictment earlier in this case, of course, but that would be an option that would be available to the court. The second option would be for the court to accept that this is a variance, which does happen and is accounted for in the case law. And frankly, Your Honor, it's not a proper subject for a motion for acquittal. In fact, date is not an element of a crime. And I know that that sounds counterintuitive, where our ICG standard jury instructions have the defendant's name, they have the date, they have venue, but venue and date are not elements of, they're simply not a factual element of a crime. And an Idaho Supreme Court's case, State versus Jones, dealt with that very issue. In State versus Jones, a defendant appealed from a lewd and lascivious conduct conviction, and he argued on appeal that the information, the charging document in that case, did not sufficiently apprise him of the nature of the charges against him. Specifically, the Jones defendant argued that the charging document did not identify the time, location, or information that he needed to prepare a defense. In that case, in that charging document, there was a range of numerous years where these crimes could have been committed. The Jones court explained that generally, a defendant cannot be prejudiced, quote, by the absence of specific details in the information when those details are already known to the defendant or are provided to him by means other than the information, unquote. And that pinpoint citation is 140 Idaho at 47. The court specifically in Jones rejected an argument about a lack of specific time set forth in the indictment. And I'll just read straight out of the case. Jones's next argument that the information was insufficient for failure to allege a specific time of the offenses is also without merit. Under Idaho Code 19-14-14, the precise time at which the offense was committed need not be stated in the indictment, but it may be alleged to have been committed at any time before the finding thereof, except where the time is a material ingredient in the offense. Time is not a material element of the crime of lewd and lascivious conduct with a minor. The Idaho Supreme Court, and I'm still reading from the case here, has stated that, quote, any other rule would too often preclude prosecutions in this type of cases where victims are minors and where crimes are not discoverable until sometime after their commission, unquote. So I think what we have here is the court explaining that these timeframes, there are other factors that can be taken into account here. And so while it's not directly on point because we're talking about a range of many years, and here we're talking about a variance in days, I think it's important to note that the court clearly didn't see a very specific tight time frame as an element of the offense in Jones. So the Jones court went on to explain that what we're really talking about here is variance. And diverting from Jones for just a moment, Jones also discussed the Windsor case, which the pinpoint citation for that is 110 Idaho 410. And in the Windsor case, the court really set forth an explanation of what variance is and the standard for variance. Quote, the true inquiry is not whether there has been a variance in proof, but whether there has been such a variance as to, quote, affect the substantial rights, unquote, of the accused. The general rule that allegations and proof must correspond is based upon the obvious requirements that the accused shall be definitely informed as to the charges against him, so that he may be enabled to present his defense and not be taken by surprise by the evidence offered at the trial, and that he may be protected against another prosecution for the same offense, unquote. And again, the Jones court, after citing from Windsor, also discussed how variance between the information and evidence presented at trial, or between the information and the jury instructions, only require reversal of a conviction where the defendant was, quote, deprived of fair notice of the charge against which he must defend, or was left open to the risk of double jeopardy, unquote.
I do have a question about variance,
Yes.
because I've looked at some of the cases that do discuss variance, including the one I previously cited, State versus Anderson, 172 Idaho 133. And in this instance, I think looking at the context of how variance occurs, I guess the point I struggle with here is it appears to me variance typically comes up when for whatever reason, jury instructions don't match the charging documents. And there is a presumption that the jury instructions should match the charging documents. And that's in a case, State versus Bernal, 164 Idaho 190. Here, essentially, what the state would be requesting is that we don't have a variance yet because the jury hasn't been instructed on something that varies from the charging document, but you're suggesting I permit or sanction a variance and allow the variance to come in to essentially cure an issue raised on a Rule 29. And I see that as very different than any of the other cases. So are you aware of any authority where the court proactively let a variance occur to fix something in order to withstand a motion on acquittal?
And Your Honor, well, a couple things. So first of all, I don't believe that the defendant did raise this specific issue on his Rule 29 motion. I understand the court is considering it at this time. But I do think that I just want to make that clarifying point because I think it goes to prejudice.
And I believe that's totally accurate. It was raised by the court.
Thank you, Your Honor. But I believe in the Jones case itself, the court, Jones, I'll just read from the case. Lastly, Jones argues that the court's instructions to the jury constituted a fatal variance because the court added, quote, on or about, unquote, to the time frame of the offenses alleged in the information. He contends that this broadened the basis upon which Jones may be convicted. We disagree. The slight expansion of the time frame does not allow the jury to find Jones guilty of a different offense than that alleged in the information. Jones has identified no fatal variances between the information and the evidence or jury instructions.
Okay, I appreciate your response to that.
Of course.
Question.
Thank you, Your Honor. So that would be the states, and I understand that I certainly understand the complexities that this course of action presents to the state, but there is that third option as well, which is obviously a clerical mistake was made here. It's inconsistent with the initial indictment. It was not it was not a proper legal amendment. We're really talking about a clerical issue here, and I think that when courts look at reopening cases, that's something the court can do for situations such as this. So if the court declines to proceed with correcting the indictment on the basis that it was never properly amended, or if the court is unwilling to proceed with a variance, the court can reopen the case to address this issue, at which point the state would then amend it before resting, which would bring the state into compliance with Rule 7E. That would put the amendment in compliance with the rules and relevant statutes. So in addressing the court's ability to take that course of action, I think State versus Cutler is a good case for that. In that case, the Idaho Supreme Court stated, a justice presiding in a criminal case not only has the responsibility of protecting the rights of one accused of crime, but also an equal responsibility to the people of the state to the end that justice is not thwarted by mistake or inadvertence. The presiding justice under the circumstances of this case are well within his rights and his discretionary powers of trial procedure in permitting the state to reopen and present further evidence after the respondent's motion for a directed verdict of not guilty had been made, unquote. And I think that's very applicable to this case, Your Honor. I also think that another case that the court could look to would be State versus Huggins, 103 Idaho 422. In that case, the court noted that some reasonable excuse, such as oversight, inability to produce, or ignorance of the existence of evidence, must be established by the moving party. And Your Honor, we're all kind of falling on our sword here. This was clearly an oversight. We're talking about a clerical error in a subsequent document that was not in the initial document. This is exactly the type of mistake or inadvertence that the court could reopen this case for. And I think defense counsel argued earlier that it would be unfair to do that after the defense made a Rule 29 motion. I'm not aware of any legal authority that supports the assertion that making an oral Rule 29 motion on totally unrelated grounds tolls the state from doing that. But certainly there might be something out there that we're not aware of. But I do think that under this case law, the court, if the court felt that a formal amendment was necessary, the court could reopen the case. Thank you, Your Honor.
All right, thank you for the citations and the well-argued points there.
All
Ms.
right,
Beatty.
Pryor.
Mr. Pryor, any response from the defense on this?
Judge, I'm going to work in reverse. And as far as reopening the case, the authority to reopen a case is almost exclusively applies to evidence, Judge. It does not apply to amending an indictment, information, or complaint. If the court recalls, I don't believe I objected to the original amendment to the indictment when we did that back November or December. The court read the indictment, went over it in detail with the state, and the state acknowledged that this is the indictment that they intended to go forward on. And from that time forward, that's the information that I relied on. And any change at this point, after the state has rested, is going to create a substantial due process argument for Mr. Daybell. In addition, it's going to affect the substantial rights of Mr. Daybell as well. The difficulty is this, Judge, is we have a very specific statute, 1914-20. 1914-20 says in pertinent part that the state may move after the defendant has pled guilty to a charge. Now he pled not guilty, and he did enter a plea of not guilty, and the state properly came forward and asked the court permission to amend the indictment. They then amended the indictment. And since approximately December of 2023, that indictment has remained in place in full force and effect. Now, they have that right to amend the indictment under 1914-20. But then we get to a very specific, a very direct rule, and that's Rule 7E. And Rule 7E says in pertinent part, Judge, that the court may permit amendment of a complaint, information, indictment at any time before the prosecution rests. To my recollection in reading the statute on this short notice, Judge, I never saw the words variance. I never saw, correct an error. I never saw anything to suggest that they have any right to do any of this. And there's a State versus O'Neill, Judge, I think it's 118 Idaho 244 that talks about Idaho Code and the statute 1914-20. But Judge, the specificity of 7E doesn't say the court has the authority to go back and allow them to reopen. It doesn't say they have the authority to go back and create a variance. It doesn't say they have a right to go back and make a correction.
He's such
What
a
it
whiner.
does say is they may and they have to make any amendments or corrections prior to resting their case. There's nothing else that says, well, we got a little bit of wiggle room here and let's let them change things after they rest their case. And 4 lawyers had a chance to look at this indictment. 4 lawyers have had over a year to analyze this. And then after they rest their case and decide that the court picks up on the fact, and Judge, I mentioned to the court that there were elements. I wasn't going to key the prosecutor off that they had a problem. And if the court didn't catch it, and there was subsequently a problem, someone else would have caught it and would have corrected it in the future. But they don't get to correct it now. They don't have any authority to say that. The cases they cite talk about other issues that have nothing to do with having the ability to change an indictment as I am preparing to present my case to the jury in this case on a murder, capital murder case. They've lost their chance. They don't get to go back. Judge, I'm asking the court to dismiss the charge.
So his argument is too bad, so sad.
All
That's
right,
his argument.
Looking back over a rule here, I have an additional question perhaps from Ms. Beatty. I'm looking at criminal rule 36 about clerical mistakes. Is it the state's contention that an indictment would be included among the documents that may be corrected for a clerical mistake? Because it does specify, it doesn't say anything can be.
It doesn't, Your Honor. And I think we take that position just based on the language in the rule that says, quote, or other part of the record, unquote. However, I will be candid with the court. I did not specifically check Westlaw to see. That was not one of my, I didn't do a deep dive into that. But I think that where we're talking about the criminal rules, judgments and orders can be amended, and any other part of the record. That's a very broad, expansive language. The record clearly would contain the criminal record in a case. I do think that that rule in its plain language could be applied to encompass an indictment.
And Judge, could I respond, please?
Yes, you may.
Judge, Rule 7 specifically says they're not allowed to change it after it rests. It's specific. And regardless of what Rule 36 says about other issues, and it's vague, we have a very specific rule being Rule 7. And Rule 7 makes it very clear. They don't get to amend. Regardless, they don't get to amend. It's a very specific rule that references this very issue. 36 is vague. This rule is specific.
Your Honor, may I briefly respond to that?
And that'll be the end of argument, but you may.
Thank you, Your Honor. The state would just reiterate that there is a process for making these substantive amendments, and there was not a substantive amendment made in this case because it did not fall within the scope of the order. And so we're not asking the court to make a substantive amendment when Mr. Pryor is citing Rule 7E or 7F. We're asking the court to correct what is clearly a clerical mistake not within the scope of the court's order, which is how I would respond to his citation of Rule 7.
Okay. So essentially arguing you moved to amend the initial indictment and the court granted the motion for specific grounds. And on February 20th of 2024, the amended indictment was filed, which has changes. And those were all drafted by the state. And your argument is that amongst the changes you put in the new amended indictment were clerical errors that should be corrected because they were not intended to be or should not have actually been amended. Is that essentially the argument?
That's correct. And I would take it one step further and say that as a matter of law, count 4 was not amended because we did not have leave from the court.
And Judge, I'd like to respond.
Okay, I will allow another response because I'm just considering all this. Mr. Pryor, go ahead.
Judge, they made the amendment to the date. They made the change to the date. They had an opportunity to review this. And then this indictment gets read to the jury and once again published for all to hear, including the 4 lawyers that are sitting across from me. And at no time do they catch that potentially there's an issue. And at this point, Judge, the rule is very clear. They have an indictment. They made the allegations. They're stuck with their indictment.
All right,
In other words,
counsel, let me
that's sad.
take a brief recess, discuss this with my staff attorney, do some quick research and get prepared to make a ruling as it relates to count 4. I think time is of the essence to determine this issue, so we'll go as quickly as we can to get back on the record. I'll have the marshals advise you when we're ready to make an oral ruling.
Wow. Wow. So, Pryor made some specific legal arguments, but in my view, his main argument was too bad, so sad, right? And by the way, while we're all here, I think we all are in need of this. We're all, so I'm giving, you get one and you get one. I'm just kidding. This is harrowing. This is absolutely harrowing. Now, I do believe that the state made some very, very good arguments. I really do. Of course, I'm very biased, and I have to recognize that. But they quoted precedent. They cited Supreme Court, they cited Idaho Superior Court law. They talked about precedent. What I want to do now is also, by the way, here is a picture of Kay and Larry. During that 2-hour recess when they were waiting for court to come back and to hear those arguments that we just heard. Very sad, very tense moments. This is ridiculous. And I think that the state is justifiably mad at themselves, and we are justifiably mad at them for not catching this. And honestly, Pryor is in his right to say too bad, so sad. You know what I'm saying? I mean, as much as I hate it, as much as I think it's bitchy, it's true. What else is he supposed to say when the state makes such a huge, huge, huge error? And I have to just remind you that the reason Lori Vallow did not get the death penalty was because of a state error. And it's so disappointing. It's so disappointing because today, as Lauren was saying earlier in that lunch live, it was a really good day. When they rested, it was like, yeah, Chad, you are fucked. They built a box around Chad and they closed it with those damning text messages. But and so when it came to the state resting, it's like we can feel satisfied, and now we'll just have to go into, Pryor bringing up his witnesses, going into his case, bringing up those, Daybell children, trying to make a case. But then this happens. Such an easy to catch error. And let me tell you, you guys, the culture at Apple was perfection, okay? If something like this happened at Apple, heads would roll. People get fired. We would sit there and read documents out loud. And, I wonder if it was the judge that caught it or if it was one of his, one of the court lawyers. Because, judges have clerks and lawyers. I wonder if it was one of them. Someone should have caught it. Or I'm not even sure if they had caught it before now, if they were legally allowed to raise it before now. I mean, again, that's a legal question. But, in the business world, especially in cultures where perfectionism is the standard, you no longer have a job when stuff like this happens. And that's not even when lives are on the line. That's just money. That's just money. And you know, all the judge can do is use the laws that are on the books and the precedent to make his ruling. Now, it's possible that he can set a precedent, but he really needs a good set of laws under which he has the authority to do that, right? To even set that precedent. He can't just go off willy-nilly. So that is why I think the state did present a number of laws and options under which the court could change the indictment, amend the indictment, create a new ruling for that. So there are some options. What I'm gonna do now is look and see if there's any outside of the court action. One moment. See if there's reactions from the peanut gallery, basically. If y'all are looking around and see anybody live outside the courtroom, please let me know. Larry, hey Tess Mac, was Larry interviewed just now? Or I know he was interviewed between, a couple of hours ago, and I did show that already. I'm going to Twitter as well. I want to see. I'm going to show this right now because I like the way Jesse Weber breaks things down from Law and Crime.
This has to be acquitted. We're going to skip ahead right now in our Chad Daybell coverage because we want to take you to a moment after the state rested their case. This is very interesting. The defense motioned for a directed verdict, meaning after everything the prosecution has put forward, there is no other conclusion the jury can come to.
With Justin Lum,
this
I'll look
has
for
to
that.
be acquitted. This has to be dismissed as a matter of law. There's nothing for the jury to decide here. But here's where it gets interesting because Judge Boyce noticed something about the indictment and had a concern about it. So after both the state and the defense gave their arguments, let's take a listen to this.
All right. Thank you for the argument. The courts reviewed the motion, which is a motion brought under Rule 29 of the Idaho Criminal Rules. And this is a motion for judgment of acquittal, which reads that we're now at the time the prosecution has closed its evidence. And if the court finds, based on the standards cited there by the state, insufficient evidence, the rule reads, must enter a judgment of acquittal of any offense for which the evidence is insufficient to sustain a conviction. I've listened throughout the trial to all of the evidence submitted. There's multiple counts in this amended indictment. As I've gone through those, I'm prepared to make a ruling on nearly all of the motion here, but there is one particular issue that has arisen in the charging document, and I'd like to address that with the state if I could. So in the initial indictment filed in this case on May 25th, 2021, and I'm looking at count 4, which is the charge of first-degree murder involving JJ Vallow. Initially, it was alleged that, quote, on or between the 22nd and 23rd of September 2019 is when the murder was committed. The state amended the indictment on February 20th, 2024, and under the amended indictment, the count 4 now reads as follows. The defendant, Chad Guy Daybell, and Lori Noreen Vallow on or between the 8th and 9th day of September 2019 in the county of Madison, state of Idaho, and then goes on to describe the allegations of
So I just looked at the Justin Lum feed, and I didn't see any interviews with Larry Woodcock or anyone. I saw him just basically giving the same recap. But for anyone who's just joining, or just to give a recap on what's going on. We are waiting for Judge Boyce to come back for his ruling on whether the state's mistake, the state made a major clerical error on its indictment for murder on JJ Vallow. The original indictment said that he was murdered on or around September 22nd or 23rd. Thank you, Crystal. I'll check it out. They amended the indictment and put the wrong date. They put the date. No, it can't apply to Lori because Lori is already convicted, and it's not the same indictment. It's a different indictment. Especially Patricia, because they severed their cases. At first they were charged together, but then they severed their cases. So it's just an indictment against Chad for JJ. But when the state amended their indictment, they made a major clerical error, and they said that JJ was murdered on or before September 8th or 9th, 2019. That was actually, I'm sorry, I think I have these. Anyway, they have the wrong date. They put the wrong date on the amended indictment. He died on or around September 22nd or 23rd, but they put on the amended indictment that it was the 8th or 9th. So this was not noticed by anyone until Judge Boyce brought it up on his own today after a motion to dismiss was argued. So John Pryor, the defense attorney, didn't even bring it up on his own. Now, it's possible that Pryor did notice it and just chose not to bring it up, and knew that it was there all along. But I actually think that if Pryor had noticed it, he would have argued about it when he argued for the motion to dismiss, and he didn't. So he was looking pretty smug. I don't think he really knew. I think he's trying this case all on his own. He's all on his own, right? So I'm gonna look. A couple of you have talked about lawyer, and he obviously knows a lot more than I do on this type of stuff. And the reason we're still live is because we are waiting for the judge to come back and issue his ruling, his answer on this. So, okay, I got it. This is he says this is his gut reaction. All right. So keep in mind, it's his gut reaction.
What's up, everybody? Literally everybody's emailing me and calling me about what's going on in the Chad Daybell case. A mistake made by the prosecution. The death date of JJ Vallow is wrong on the charging document. I've had some people actually call me and email me that are in the courtroom, in the courthouse
Great Dane Mom, my email address is disorderinthecourt2 Thank you very much. And I agree. I think that Pryor's ego is so major, is right up there with Chad's, and that he would have thrown it in their face because the state rested, and he knew that he would have known that after the state rested, they can't change it. So he would have thrown it in their face. He would have loved to have that opportunity to be the one to throw it in their face. And he probably, when, he was sitting there looking all smug and happy when Judge Boyce brought it up, as if he knew what was going on. But probably in all reality, he was sitting there thinking, God, why did I, geez, why didn't I catch this? So none of the lawyers, in my opinion, none of the lawyers caught it. All right, let's listen to lawyer,
Watching the case with some people involved, they told me that it was a Scrivener's error, that on one of the edits of the charging document, the state accidentally changed the date, didn't mean to, and that during the JOA arguments or the arguments made by John Pryor, Chad Daybell's attorney, he didn't even bring it up, but the judge brought it up and said this death date is wrong. And it was after the state had rested their case in chief. So what happens now? There are a couple different scenarios. One is that the case could get thrown out. The JOA could get granted, and the individual charge against JJ could go away, but usually only if the defense has made the death date one of their big arguments, meaning he wasn't there on that day or the victim was still alive.
See, that's a really good point. And that was kind of noodling around in the back of my mind as, the death date hasn't been a point of contention. It's not like there's that's on the table. It's not like John Pryor has had all kinds of points of inquiry about the date of death, right? And even when all this evidence came in about, this is JJ's last known, of image of being alive, all that stuff, none of that was objected to. He's not even denying that JJ Vallow was murdered. He's just denying who murdered him and how it was, that Chad was involved, right? So let's keep listening.
Past that day, and the state was using it as one of their big arguments. Doesn't seem like that was something that happened here. So much so that John Pryor didn't even notice that the date was wrong, and the judge had to point it out. So
right. So he's even saying that Pryor didn't even notice. Again, I think that if Pryor noticed it, he would have been the one to throw it in their face at the appropriate time after the state rested, so they can't take it back, or so they would still have to be in this same argument.
Doesn't seem like there's going to be any major prejudice. This has actually happened to us in some cases, and the judge in all of our scenarios, and in most of the scenarios, they will just let the case let the state reopen the case, fix the Scrivener's error, change the date, and just keep moving forward if it doesn't prejudice the defendant enough.
So that seems like a very, very quick, easy, low maintenance fix. Very easy. So I'm hoping that we aren't all having this heart attack for nothing. Sorry. I hope we are having this. I said that the wrong way. I hope we're all having this heart attack for nothing.
So that is option number 2 that can happen. Option number 3 is we can have an argument, we can have a hearing, the judge can hear arguments from both sides and ultimately make a decision only on JJ's.
That's the other thing you guys are talking about. There was all this discussion between the lawyers and the judge and Pryor and the judge about, the indictment being read to the jury. I don't remember it being read to the jury. Usually it's read, usually it's being read right before they, either at the beginning of the trial or right before they go into deliberation, right? I don't remember it ever being read. So, right, Scrivener's error.
case. It doesn't mean all the charges are going to go away. It doesn't mean Chad Daybell is going to walk away scot-free. The other charges against Tylee and Tammy will still go forward. It doesn't seem like there are any issues there from what I'm hearing from people in the courtroom. Again, I haven't watched this or read this myself, but this is the question everybody has. If the death date is wrong and the state has rested their case in chief, is it over? Do they lose? Does Chad Daybell win as far as it's concerned with JJ? And the answer is not necessarily. So it depends on what the judge decides. It's within the judge's discretion. I would expect the judge to allow the state to fix their Scrivener's error if they find that it wasn't prejudicial enough to the defendant. And if the state was allowed to, after acquitting the defendant, change the date, bring the case again, try the case again, and nothing would really change, then how much does it really prejudice the defendant? So that's a question for the judge. We'll keep an eye and ear out. Let me know what your questions are in the comments below.
Oh my God, are you okay? Sorry. I hate how
I didn't see
quickly
her.
it goes.
Is this a case of distracted
Sorry, guys.
driving?
Hold
A
on.
woman live streaming on YouTube apparently runs over a pedestrian.
Isn't that crazy? A YouTuber ran over a pedestrian while live streaming. And you ask me why. You ask me why I have issues with social media. You see what's in my algorithm too. YouTuber runs over pedestrian. Anyway, right here is the actual posted by Justin Lum. Here is the actual indictment with the there is the indictment with the typo. You can see it on the first line. The defendant, Chad Guy Daybell, and Lori Noreen Vallow on or before between the 8th day of September 2019. There it is. There it is. Man, what a nail biter. I sincerely hope that this was all this heart attack creating is just gonna be all for nothing. It was just a Thursday surprise. Yeah, I saw that, Patricia. I saw that. Wasn't he on his way to some sort of looking for a child? Wasn't that like searching for Sebastian Rogers, and he dozes off at the wheel? And you all wonder why I have an issue with social media. I know you don't wonder, but I'm just, it's a figure of speech. Anyway. Yes, exactly, Tess Mac. A short day that turned into a long, stressful day. I mean, we ended today's stream feeling so good about how the prosecution rested their case. They made such a strong case. We had our, Camille Vasquez #2, aka Lindsay Blake. She's a really good litigator. All of them are good. They're good. They're so good though that they aren't, whoever their team is, whoever that Scribner is, who is responsible for creating these documents and then reviewing these documents, need to take their ADD medication or something. They need to focus. They need to get more sleep. They need to pay more attention. They need to know that these kinds of things cannot go unchecked. This is critical. Janice in accounting, it wasn't like a major YouTuber, and it's on Law and Crime, that video. The video where it says, the video is called "YouTuber Runs Over Pedestrian," she says, while driving, she says. So just so you know, we're waiting for Judge Boyce to come back from making his decision. We're looking at the actual indictment with the mistake on it. I'm now going to look and see if there's anything else live in the live outside of the courthouse. Please remember to hit the thumbs up. Thank you very much. Consider becoming a member if you aren't already. Oh, that YouTuber smokes pot on live streams. Good for her. I mean, if you're going to be smoking pot on live streams, you also probably shouldn't be driving and live streaming. I mean, right? Right? Yeah, I'm not seeing any court action. Let me see if there's anything on Facebook. I haven't been able to see anything on Twitter. See if there's anything on Facebook. So on Facebook, Nate Eaton has posted the two different indictments and the differences. So this is the one that was filed on May 25th, where it says on or between the 22nd and 23rd day of September 2019. And then here's the one that was filed, and that's the wrong one. Unbelievable. Unbelievable. So we are waiting for them to come back on the ruling. We're waiting for them to come back. In other news, I noticed that Jim Brennan, the man who was accused and had always been alleged or thought to have killed Dylan Rounds, was going to be in court today to plead guilty to the murder of Dylan Rounds. So that is, finally we have some closure in the case of Dylan Rounds, where he was, his murderer finally faced court, went into trial, and pled guilty. Let me see if it's. Oh yeah, actually it was yesterday. So finally, I don't think he ever gave a motive. He got he got 1 to 30 years because he pleaded down. So while we're waiting for while we're waiting for the Idaho court to come back, let's watch a different piece of crap plead guilty to the senseless murder of a young man who didn't deserve it.
The appropriate pleas and is prepared to sign or has already signed the plea agreement. So he's prepared to actually submit them to the court right now.
I think there might have been just one, maybe I missed it, Mike, but I think that there was one provision that was missed, which is that the party stipulate defendant will not receive credit for any time served on any case, whether state or federal, other than time served in the two cases he's pleading to. But just to be clear, I believe that that's only about 17 days-ish. So
that is correct. What Mr. Wardle said is the part of the plea agreement.
All right, thank you. Mr. Brenner, as your attorney explained with Mr. Wardle's clarification, is that your agreement in this case?
Yes.
All right.
Well, gosh, it isn't fantastic. It's not very fantastic that his lawyer is completely blocking his view. Oh, Great Dane Mom, please be careful as you're driving around. Oh, they're back in court. They are back in court. Hear ye, they are back in court. And I'm doling out the Xanax.
All right, we're back on the record on CR 2221-1623, State of Idaho versus Chad Guy Daybell. We took a recess after argument on continuing issues the court raised on the defendant's motion under Rule 29 for a judgment of acquittal, and in particular as it relates to count 4, after noting that the dates of count 4 in fact were dates that matched those in count 2 relating to the alleged murder of Tylee Ryan on JJ Vallow's count 4 dates. So the court allowed time for the state to research and further argue, as well as the defense. And the courts considered those arguments, and at this time we'll make a ruling as it relates to count 4 of the amended indictment. First thing I'll note is at the stage we're at this point is a ruling on Criminal Rule 29, which is for a judgment of acquittal. I already indicated the standard and the case law as it relates to the burden that the state has on that. I went through the other counts and denied the motion and reserved ruling on this count 4 for further research and consideration. The court, having considered the arguments of the state and the defense, I'm going to rule as follows as it relates to count 4. First of all, the court would note that the state has argued that in its motion to amend the indictment, and I'll note the indictment initially was filed in this case indictment, which has governed this trial, was filed on February 20th of 2024. So there was a time frame between May of 2021 and February of 2024 where the governing charging document was the initial indictment filed in this case. The state, by motion in November of 2023, sought to amend the indictment, and the court went back and reviewed that motion to amend the indictment, and specifically leave was sought as required by the rule to amend counts 1, 3, and 5. And the court did have an objection filed, ultimately issued an order on December 8th of 2023, granting permission to amend the indictment. Among the charges sought to be amended count 4 was not one of those. So when the amended indictment was filed, it did have an alteration on count 4. And so the court thinks it's important here to consider this procedural history. The original indictment on count 4 sets forth the dates of the alleged murder of JJ Vallow of honor between the 22nd and 23rd of September 2019. The state's argued then this is a clerical error that should be allowed to be cured, among other arguments. And looking at the history of the proceedings here, the court can make some conclusions. Number one, the court didn't permit or authorize any amendment to count 4 in the new amended indictment. So count 4 should not have been amended. Second, the dates that were put into the count 4 of the amended indictment of 8th and 9th of September 2019 mirror those dates of another count, count 2, which is the alleged murder of Tylee. Looking at that history, I think the court does believe it's a clerical error that led to the change of those dates. And so then the court has to consider whether or not there would be prejudice is one of the things I need to consider, the manner in which this could be fixed if it could, and whether or not there's any prejudice to the defense, which is always a big consideration and what the rules govern in seeking to protect due process rights of defendants. The court would note I also have to weigh that out with the right of the state to seek justice in a case with the charges it's filed. The state's argued it should be allowed to cure this, that it's a clerical error. The court notes that the defendant was on notice for a period of several years from May 25th up until that amended indictment in February of 2024. So nearly 3 years that the allegation was this murder of JJ had occurred on or between the 22nd and 23rd of September. In addition, the court would note that the evidence in the case all pointed to the dates of the 22nd and 23rd of September. And not only that, that same allegation's been made in a previous case that was tried last year by this court of co-defendant Lori Vallow with those dates. And of course, the defense here was aware of that trial, the evidence in that case, and a resulting conviction. So there's certainly no surprise that would come to the defense knowing that the dates that have been alleged are the 22nd and 23rd. So in terms of any prejudice, I wouldn't find that it would be prejudicial at this point to permit the amendment of the dates. The matter before the court now is just simply whether or not a Rule 29 motion could be granted, and then additionally, again, what could be done to correct this if it can be corrected. Going back to count 4 of the amended indictment, if I were to disregard the dates in there, the court does find there's been sufficient evidence in terms of the elements that are alleged, that the defendant, Chad Guy Daybell, was identified by multiple witnesses, including Ron Arnold and Whitney Arnold, that in terms of the elements of the murder that are alleged, there was testimony from Brandon Boudreau and Garth Warren, among others, about this alleged count of first-degree murder involving JJ Vallow as a victim. And he was also identified by those witnesses, and then other testimony from numerous other witnesses that testified about the murder of JJ Vallow in this case, lead the court to believe there's sufficient information under Rule 29 that the motion for judgment of acquittal would be denied on that. And then leaving for the last part of the analysis here, the dates, the court having considered that history and the fact that count 4 just never should have been changed because there was no permission to do that, I do find it's an inadvertent mistake. I have also seen case law cited by the state that the actual date or time of is not necessarily a required element of the murder charge. So while these jurors have already heard the information contained in the amended indictment, the court believes that the jurors can be fairly and properly instructed with a curative instruction or some other manner in which to correct what they've heard so they can properly be instructed in conformity with the evidence submitted. So the only determination the court makes here today is that the motion for judgment of acquittal as it relates to Rule 29 is going to be denied. And on one final point of that, I'll also mention that it was a matter the court raised itself. It was not specifically argued by the defense. And so the court again finds it's not prejudicial at this stage of the proceedings to allow for that change to occur. What I don't feel like I have had time to properly and fully ferret out on the issue is precisely how that will take place, whether it's through a allowance under Criminal Rule 36 has been suggested, an amendment to the charging document, or simply a curative jury instruction or explanatory jury instruction. I need some additional time to think about that. But for purposes of allowing the defense a fair opportunity to be prepared going forward with its case in chief, I am making the ruling that the Criminal Rule 29 motion on count 4 is denied. So the case will move forward. That count will be included in the court is going to issue a substantive follow-up order to the parties that will be directive in how the court thinks it's best to cure the mistaken dates in count 4. So that's the final ruling on the motion for judgment of acquittal. Ms. Beatty, do you have any questions about that ruling?
And Your Honor, do you need any further briefing from us or anything of that nature?
I don't believe I do at this time with the ruling made.
Thank you very much, Your Honor.
Any questions from the defense?
No, Judge, thank you.
Okay, thanks all for your consideration this afternoon. We'll be in recess until Monday morning for the defense case in chief to begin.
All rise.
Hallelujah. Hallelujah. Damn, y'all. Damn, y'all. Damn.
Turning to additional.
That was a freaking nail biter. That was a nail biter, and Judge Boyce freaking came through. A freaking men. Judge Boyce will not throw out the indictment. The motions to dismiss are dismissed. Great Dane Mom, if you're there and you want to join, that link I just shared is for you. If you want to join us from the courthouse steps and tell us what the mood is, let us know. And you know, I've had these things prepared for you in good moments or bad. Take them safely. Don't take too many of them. Just one, okay? But seriously, I mean, I had a sense that he was going to go in the right direction. I had a feeling, but you just don't know if that feeling is going to be carried on. Is right. You know, is this a feeling I'm having just because I want to have a feeling? Or is it because it's true? But I guess it was true. And when I knew it was going in the right direction is when he said that they did not request for that particular count. Take one down, pass it around. 99 pills of Xanny on the wall, 99 pills of Xanny on the wall. Sorry, I'm being silly. I'm elated that at this outcome. Thank you, Judge Boyce. I was a little nervous. Music City Mom, that's funny. I was a little nervous at first because his voice sounded shaky. His voice sounded shaky at first. Almost like he was nervous about what he was going to say, but I think maybe he was nervous about whether the state was going to argue well enough for him to make that decision. That's what I'm now that's my read on it, is that he was nervous about whether the state would make cogent arguments that he could rule on, right? Hey, Great Dane Mom, I shared the link so you can join if you still want to join from the courthouse steps and, get people's reactions. I'm going to also check around to see if anybody is live around there. So that was a nail biter, but, and the state better have done a good job, because that was a major error. They can't make errors like that. They just can't. And it was some fast thinking. It took 2 hours for them to pull together a very, very solid set of arguments with a lot of case law and precedent. But that takes 4 lawyers, and that's with 4 lawyers and a staff to help them out. And I'm sure that as soon as they heard this becoming an issue, all of them were starting to scramble, right? And you saw those 4 lawyers sitting at the table just with their head in their hands. I mean, this is absolutely nuts. You're not tech savvy trying to join, but it says it says your camera and mic aren't working. I guess you're on your phone. You probably have to usually it gives you a prompt, Great Dane Mom, to be able to connect your mic. It gives you some sort of prompt, but it's okay. Don't worry about it. It'll totally be okay. We will live, but we very much appreciate you. You can tell us in the chat what's going on there outside. Do you see anybody else on camera? Everybody was freaking out, Chopper. Everywhere. Everybody was freaking out. I was freaking out. Literally, I was sitting here frozen for a good 5 minutes trying to figure out what the hell am I going to do? I need to gather my people so we can watch this together. But, it's so easy for me to break into a ugly cry. And I need to hold it together for you all so that I don't make you guys break into an ugly cry. I had to pull myself together before I went live, because I don't know. I'm very attached to this case. It has a very, very warm place in my heart. Well, Johnny, we just narrowly escaped JJ Vallow's indictment being thrown out because of a clerical error from the state. Literally the wrong date on JJ's indictment may have caused it to get thrown out, and the state had to scramble at the last minute to pull together an argument about their clerical error. And it's just making me worried for their work on the Brian Koberger case, because that is a major case. And a lot of the same team. Johnny's probably been asleep. It's super duper late where she is. She's probably been sleeping. But I am, you just can't, you gotta double, triple, quadruple check your work in cases where there are such high stakes, such super high stakes. And it was nice to have the perspective of, someone like lawyer, who knows like the ins and outs. And it really goes to show you that when you can't rely on the uninformed opinions of non-lawyers in situations like this. Like me, I'm not a lawyer, so I couldn't tell you what the outcome was going to be here. Right? Yeah, I appreciated that too, PKC. And I'm glad you guys told me that there was a quick video about that, because it was helpful. So just before I end this stream, a very quick recap. there was a very, very good end to the state's case today. Earlier, they closed out their case with a bang. They closed those walls in so hard on Chad Daybell. They showed that he conspired with his wife, his current wife, and with Alex Cox to kill 3 people. Okay? They showed that. He's fucked. They rested their case, and then as Pryor was issuing a motion to dismiss, which is a normal, regular part of the judicial process in these criminal cases, the judge noticed a clerical error in the indictment and said that it's possible that that particular indictment would need to be dismissed because of that clerical error, because the state had dismissed its case. And so the state and the defense then had to argue on that situation. And the state and the defense had 2 hours to pull their arguments together. We sat here on pins and needles waiting for that. Then we watched their arguments. Then we waited on pins and needles for another half hour waiting for Judge Boyce's decision. And then he just gave the decision and said he's going to, he accepted the state's arguments. And basically what it was that when the state requested to amend the counts, they did not request to amend that particular count. And since they, oh, please, no fights, no fight. Let's not fight over creators in my chat, please. Let's not talk about other creators in my chat. Hopefully you're not serious about that. We don't need that. I don't have any particular opinions. I have a situational opinion of a lawyer, and that situational opinion was I was really happy about that video that he played, that he put up. Oh, it's a fight over a man. I got it. Cause he's kind of good looking and people like him. I gotcha. So, oh shoot, I was about to get something for you guys and now I forget what it was. Shit. Oh yeah, that's what I know. Anyway, so I've been live streaming this trial pretty much every day. I've missed a couple of days due to my own personal clerical errors. But I am streaming this every day, and it's something that is very close to my heart. So I hope you'll continue joining me here. Tomorrow, it sounds like Pryor is going to be starting his case in chief, his defense. And then probably pretty much next week, we're going to be going to, I would guess that by the end of next week, it'll be going to the jury. What I'm looking forward to is hearing the kids testify, what the kids have to say. What on earth could they possibly say to defend this behavior that we've seen play out in court? These text messages where they're talking about issuing pain to children. What could they possibly do? What could they possibly say? What is a good reason for them to defend any of this behavior? Just that they didn't see it? Why on earth could they? Yeah, I believe there is court tomorrow. I don't think they said anything about there not being court tomorrow. If anybody knows differently, let me know. But you will know I will research it before I schedule the next stream about court. Oh, no testimony tomorrow. Court resumes Monday. Huh. Huh. Well, thank you, One Juror Matters. I will, for this moment, I'll take your word for it, but I will also just double check that myself. Yes, okay, thank you. Now I've got 4 people saying this in my chat. I believe you. I believe you. So we will continue on Monday. Tomorrow, maybe I'll probably stream something else tomorrow. I don't know. We'll see. I might stream something else tomorrow. I am engaged in at least watching the Karen Reed case, but I got to tell you, it aggravates me watching it. It's aggravating to watch. So anyway, Great Dane Mom says, Great Dane Mom is at the courthouse right now. So she's giving real-time color commentary. Kay and Larry came out with big smiles. I met them during Lori's trial and Larry recognized me. However, they are running to catch a plane. Larry stopped for a quick moment to speak with media. Okay. Thank you very much, Great Dane Mom. That's very good to know. I'm glad that must have been such a relief to them. And, you know, that's who I feel such relief for, is really them and their JJ's family members. And you can hear me getting emotional now. They're the people I feel for, you know? So, and I'll tell you the reason I'm getting aggravated. I've been aggravated about this Karen Reed thing. I literally have no idea whether Karen Reed is guilty or not. I don't have a strong opinion on whether Karen Reed is guilty or not. I just cannot stand people being badgered on the stand. And I can't stand the cognitive dissonance. I don't understand the fucking harassment of people by bloggers, you know? What, if anything? That all parties in that case, all lawyers in that case are bugging me. The prosecution is bugging me and the defense is bugging me. Everybody. It's all annoying because the prosecution seems totally incompetent. And then on the prosecution side, I'm sorry, on the defense side, they won't listen to any freaking reason. You can't have a normal conversation with anybody on the defense side. They won't listen to just a question. All of a sudden, you're put into some certain category, and you're not to be fucked with. I don't get it. That really pisses me off. So anyway, I'm getting a little bit far afield from. Anyway, so we will continue this case coverage on Monday. Thank you all for correcting me. And yeah, hopefully the Koberger team will learn from these terrible mistakes that have been made on both Lori's case and on this case that could have been catastrophic. It could have been catastrophic. So thank you all for being here. Thank you for being respectful in the chat and for your wonderful comments. And thank you, Great Dane Mom, for your color commentary. And stay safe there. And thank you for bringing your doggy to be a emotional support on Tuesday. And I will see you all very, very soon, if not tomorrow, on Monday. All right? Have a great rest of your day. And thank you, Judge Boyce. Thank you. Not that you did me a favor. Just thank you for making that decision. Bye.